that I get the pleasure of introducing Roger Noll. Now, Roger may or may not remember this, but in 2008, the very first conference I organized at Penn, he was one of the initial speakers on the first panel on a conference on the 25th anniversary. It seems so quaint now. The 25th anniversary of the breakup of AT&T. And I think it was someone had the bad grace to point out that, in fact, the decision breaking up AT&T was in '82, and the breakup actually happened in '84. And I actually did on the 25th anniversary of what had been 1983, so I did actually the 25th anniversary of nothing that's going to split the difference. But it was the year I joined the faculty, so it seemed to make sense. And Roger was, I think, was nice enough to grace us then. He's actually joined us in other conferences we've organized in other parts of the world, and I'm really delighted to call him one of my friends. What you'll discover is he's going to talk about baseball. He's one of the leading sports economists. He's one of the leading positive political theorists in terms of public choice economics. And in fact, one of the things I love about his work, I actually signed the work of yours I did assign to this class. Is something near and dear to my heart. I grew up in a town of national labs. I grew up in Oak Ridge. And he actually asked the question, what's the role of government funding of national labs in this overall space? Fabulous economist who also helped part of the breakup of AT&T as well on the Antitrust side. I hand it over to you to give us the insights to cap off what's been a terrific day.
Thank you, Christopher. It's always fun to be here, and I'm glad to have the opportunity. I've actually altered what I'm going to say in response to all the papers that came before, because it's going to take me my entire allotted time to correct all the mistakes. And Shane, I'm going to start with you. I can do this to Shane because I've known him since he was a mere pup. Okay, now the real motive for what I'm going to actually talk about the role of antitrust and innovation. And the motive for it is reading not one, not two, but three amicus briefs filed by the Department of Justice in an antitrust case brought by the Federal Trade Commission. And these three were all filed within a period of 4 months. This is FTC versus Qualcomm. And I'm not going to talk about the prohibited subject, which is FRAND, which is actually the subject of the litigation. Instead, I'm going to talk about a theme that's in all three of these amicus briefs by the Department of Justice. But just bear in mind the political economy implications of this. People from the same administration, from two different agencies, are battling each other in court on the opposite side of the same case. All right? And so where in the world did this come from? Why does it exist? And now, the underlying economics of it are all crazy, and my discussant's already written why. So I don't have to go into that much, but I'm going to summarize some of it, all right? But first of all, what is the underlying argument? The underlying argument of the Department of Justice is the pipeline theory of innovation, which I'm now divorcing him. I no longer claim him as a former student, called mainstream economics. I would have some other alternatives for it. Backwater economics, diversion canal economics, or how about swamp economics, which is more contemporary. So let's drain the swamp. The, quote, mainstream economics version of the innovative process is a partial equilibrium microeconomic theory, basically a price theory approach, rooted in some ideas in economics that are from the 1950s and early 60s. That's what's mainstream economics. It is partly what Shane said, the pipeline theory, which is basic research comes in here, and then a series of institutions, starting with the government and universities and ending with the private sector, produce products that come out the other end. Moreover, this pipeline at the innovation stage is Thomas Edison. In other words, the maintained hypothesis is there's only one innovator in the entire economy that's relevant to this particular case that we're interested in. So all we need to worry about is the person at the end of the pipeline who is working in his lab in Menlo Park, New Jersey, trying to produce the light bulb, and how much of an incentive are we creating for this person to produce still better light bulbs. That's what it's about. And then the second part of the story is the market failure story, which hit its peak with a paper that was published in 1958 by Jesse Markham called The Anatomy of a Market Failure, which goes through all the ways that markets can fail to produce optimal outcomes. One of which is information impactedness, another of which is lack of appropriability. And that was the state of economics circa 1960, was to think of the world in this way. The place where it unraveled is when economists began applying the market failure theory, not to the innovation process, because that's really hard. It takes a lot of data that over a long period of time to figure out. The first place to try it was economic regulation. Is it the case that the reason we regulated trucks, we set the price for trucking, was because of a market failure, a natural monopoly, information impactedness, environmental externalities? No, it wasn't. It was we wanted truckers to make more money, all right? And there was a whole concept of regulation is actually captured by the industry to benefit the industry, which is sometimes true and sometimes not true. But that whole finding that at least in some cases, that's what regulation is all about, put an end to mainstream economic theory about how you think about public policy. Now we're all the way up to 1965, right? So we still have 55 years to go for swamp economics to develop. And that's what we're going to do today, is economics in the more interesting and full of life swamp, with many more things alive and squirming about than in the mainstream. Okay, so the Justice Department's view is essentially the following, that an antitrust case based upon leveraging a monopoly attained for a pro-competitive purpose, in this case, a patent, into perpetuating and maintaining a monopoly in something else where you don't have the intellectual property protections or any other kind of source of underlying market power, namely chips, that somehow that's okay because it increases the return to the innovator, in this case Qualcomm, and therefore makes this firm at the end of the pipeline more innovative. And then, of course, at the bottom of this is we just have to assert why this is true from an economic efficiency or cost-benefit standpoint, and it is falling back on this sort of generic argument, which is true, but it's hard to see how it applies in a specific case, that almost all of the increase in per capita income that's occurred in the history of mankind occurs because of technological progress. There's only three ways productivity can go up. One is you find more natural resources per person. The second is you have more capital investment per person, the capital deepening. And the third is you innovate. You have better ideas, you combine factors of production in a better way, and so labor productivity goes up. Those are the three ways that growth in per capita income can happen. So the argument is really simple, that if we give the innovator, Qualcomm, more incentive to innovate, as witness, and he legitimately, because this guy has a patent, therefore it must be good. It must be something really useful that this person produced, and it provides market power. That therefore, letting them do whatever they want with it is okay, because it leads to this growth in per capita output of a generic sense that arises from innovation. So now, that is not a cartoon that I've just painted. That's actually the argument of why we don't want to apply antitrust as a serious constraint in innovative markets. All right? It's actually the serious argument. Now, the thing that's wrong with it, of course, is what you've spent the entire day hearing people talk about, that it abstracts from a whole bunch of stuff. And I'm not going to reprise everything that's going on today. I just want to say a couple of things about that. And that is that unlike, mainstream economics, swamp economics recognizes the fact that, A, innovation is in the pipeline. It's lots of interactions between customers and sellers throughout a long chain of products, even interactions among people who are producers of complements that go into complicated products. The normal product isn't an electric light bulb manufactured by somebody in Menlo Park on the basis of working in his lab for a few years to figure out how to make it. The normal product is a cell phone, which is full of different components, both hardware and software, invented by different people. And anything you do to change the property rights, the degree of bargaining power for any person involved in the production of this complicated product will have as one of its effects the reallocation of the rents arising from the productivity advances of all these innovations among the various innovators. Consequently, if you haven't gotten it right to begin with, all right, you could imagine you could increase total innovation by changing the way these rents are divided among all the contributors to the complex product. But for the most part, you're probably going to get it wrong if you only focus on one component and say, give that person as much as possible. Because what that might do is enable that person to strip the rents away from all the thousands of other component makers, thereby eliminating the incentive to innovate for everybody except the one person you've sued. All right? So that's what's fundamentally wrong with the pipeline theory as applied to most of the things we find interesting. That's the first thing that's wrong. The second thing that's wrong is that most of what we observe in the economy is not either a single product industry with a monopoly or a homogeneous multi-firm market that is essentially perfectly competitive, which is the underlying assumption of most of price theory. Instead, it is a strange monopolistic competition phenomenon where the way people compete is partly on the basis of price, but also partly on the basis of the attributes, the performance attributes of what they make. And again, these performance attributes are based upon differences in the combinations of all these thousands of other inputs which have their own history of innovation. So the products actually come out looking different a little bit and not being completely perfect substitutes. And in a world in which that's what most products are, and you know, obviously, if people can be convinced that various brands of cola are different, then they can certainly be convinced that most brands of high-tech products are different. And the way competition works in those industries is partly on the basis of price, but it's mainly on the basis of entry. The way you cause firms to earn competitive profits in a monopolistically competitive industry is by having entry proceed to the point where it's no longer profitable to enter. So in that kind of an environment, an action that can reduce entry, can reduce the number of firms who compete against you, is very beneficial. It wouldn't necessarily be beneficial in a standard, homogeneous product, perfectly competitive industry, because in that kind of an industry, it doesn't really matter whether there's 20 or 200 or 20,000 firms. If you have a large enough number, price competition alone is going to get you the result that there's little or no excess profits. But in a monopolistic competition environment, that's not going to happen. It can be the case that if you blockade entry at the level of 20 firms, there's still some firms in the market who don't have anything competed away from them. There's no entry to come and take it away from them. So, now, having said that, we can all assure ourselves the lawyers and the economists in the Department of Justice would not at this moment have learned anything by what I just said. They know this. All right? So, I'm going to address why they made this argument. And it's about a feature of Ninth Circuit precedent, which is spreading to the rest of the country. And the Ninth Circuit precedent is most clearly articulated in a case called Tyco, but it's pervasive in lots of other antitrust cases that have appeared in the Ninth Circuit. And indeed, it's spilled over from technology cases into cases that don't have any real high-tech implications, like the O'Bannon case, the antitrust case against the NCAA about college scholarships, names, images, and likenesses returns, which is a peculiar way of implementing the rule of reason test in an antitrust case. And that basically goes as follows. what it's supposed to do is as follows. All right, that the job of the plaintiff is to show that conduct by the defendant was A, anti-competitive and caused harm, B, caused harm. All right? Once that's happened, then the defendant can come back and say, aha, there's an offsetting pro-competitive benefit. That yes, there's that cost. We did it, and yeah, it did have this anti-competitive effect. But there's a pro-competitive effect that's even better. All right? And then the plaintiff can come back and say, oh, yes, that's true, but you really didn't need to do it as anti-competitively as you did. There is a less restrictive alternative that would have preserved, that would have caused the benefit-cost ratio to be even higher. And you didn't do that. All right? So now, plaintiff gets to step 1, defendant gets to step 2, plaintiff gets step 3, plaintiff should win. All right? That's not the way it works in most of the circuits, actually, but especially not in the Ninth Circuit. In the Ninth Circuit, the test is different. Step 1 is the same. You show there's anti-competitive effects. Step 2 is you don't show that the pro-competitive benefit is offsetting. You just show that it exists if it's innovative. Okay, that is to say, if I implemented an innovation that made the product better in some way, then I'm done. That offsets any anti-competitive effect no matter how big. And that's because, it's understandable why somebody would do this because it's extremely difficult to measure the effect of an innovation. So imposing a burden of proof on somebody to prove that the pro-competitive benefit of a technological innovation was X dollars, where X is some number bigger than the Y dollars of the anti-competitive harm, is extremely difficult. And I can see someone arguing, well, if we assign such a high burden of proof to defendants, they can never win, and we're going to end up snuffing out a bunch of innovation. But regardless of how you feel about that question, that's what the test is. And then the third part of the test, which is how the plaintiff is supposed to respond to that, is that the less restrictive alternative must preserve every single penny of the pro-competitive benefit. That is to say, you can't show that there's a less restrictive alternative that would have reduced the anti-competitive effect by $1, but left 1 cent of pro-competitive benefit left that was not captured in the new by the less restrictive alternative. So in my example, we have 100-to-1 difference between the reduced anti-competitive effect you could have versus the pro-competitive benefit you would lose. And you still lose the case. Now, what this means is it really gives a position of privilege to innovation. All right? And that's sort of an intriguing idea, but it certainly is worth debating whether that's how we want to go. Where it's now, and I'll give another example of a case that did this, which is the iPod, iTunes Antitrust case in the Ninth Circuit, where Apple was charged of undertaking an innovation in iPods that had 2 effects. The first was, allegedly, that it increased the security of the digital rights protection system for the songs that were being downloaded from the iTunes store to the iPod. Now, and then the second thing it did was it fixed a hole in the system that real networks had exploited to make it possible for someone who owned an iPad to buy their music from someone other than Apple, the iTunes store. All right, that was what the case was all about. The anti-competitive benefit, the pro-competitive benefit of increasing the stringency of protection was somewhat mooted by the fact that 4 months later, Apple started selling its music without any digital rights protection. So it couldn't possibly have been the reason for the innovation that they wanted to protect the digital rights system that they were about to abandon. But nonetheless, the Ninth Circuit found that for those 4 months, there was this pro-competitive benefit, namely there was a more secure system of protecting the music than otherwise would have been the case. And therefore, whatever the anti-competitive losses were, wasn't enough, because there was no possible way to capture all the benefits on this digital rights protection scene. All right, let me go on to another example. The basic story I want to tell here is antitrust rules of thumb, as actually executed in the legal system, create for themselves a series of incentives about where to allocate innovative resources. And what the Ninth Circuit standard does is give somebody a roadmap about how to engage in anti-competitive behavior. And the way to do it is that any innovation, however small, can shield you from any anti-competitive conduct, however large. That's the implication of it. So guess what happens to investment in R&D and innovation in high-tech industries that have this feature, like the iPod, iTunes has this feature. There's not only the intellectual property of Apple in some components of the iPod, but there's also intellectual property in all kinds of other components, and there's intellectual property rights involved in the music. And if you engage in an act that transfers the rents that would have gone to all these other players to yourself, and you do it in a way that has some technical benefit, you're home free. Second example that I want to turn away from the Ninth Circuit to get at the next example, which is how institutional arrangements and rules of the game of a regulatory nature that partly, in this case, affect antitrust, but partly also affect the regulatory system, create perverse incentives for innovation. And the example I want to use is from another prohibited topic from Christopher's marching orders, but I'm not going to talk about the prohibited part. The prohibition that I was given is I can't talk about reduced payment settlements of antitrust cases, of patent infringement cases in the drug industry. So, of course, what I'm going to talk about is a reduced payment settlement of an antitrust case in the drug industry, but I'm not going to mention the fact that it's a reverse payment, because that's not the feature I want to talk about. What I want to talk about is the regulatory rules of the game pertaining to how you get to enter as a generic. And the how you get to enter as a generic part is driven indirectly by patent law, but is mainly driven by FDA regulatory procedures. Briefly, and I apologize because the world's leading expert is sitting over here, he's my discussant. If you want to know how this works, he's written about 480 pages about this, so I'm just going to give a very brief summary. But the basic story is as follows. Depending on the actual nature of the drug in question, the generic drug rules give the brand name drug a period in which, even if you as a generic believe their patent is invalid, you still can't enter. You still can't get, the laws prohibit you from just entering and risking losing the infringement case. All right? So there's this period of time, once a drug is accepted by the FDA, given a license, the brand name drug, that there's a period that the generic can't enter. And the period is variable, depends on the nature of the drug, but I'm not going to go into that because it's not an important detail. The important point here is, once a generic has said, we're coming after you, then there's this additional waiting period. And during that waiting period, if you can somehow reinvent the drug and get a new patent and get a new FDA license, then the generic cannot effectively enter against you, because if your new drug has any difference from the old drug, the state generic substitution rules don't apply. State generic substitution rules is you get a prescription from your doctor to take dibolbulin trisulfate which we'll call that the brand name, and somebody has come out with a generic version of it. If it's identically the same in terms of active chemical ingredient and dosage, then indeed the generic substitution laws say the pharmacist can recommend to you that you take a generic instead and save 90% of the cost. But if there's anything that's changed, so your generic is a drug that's not on the market anymore, and the brand name drug is something else, then the generic substitution laws don't apply. The pharmacist can't even give you that advice. So what does that do? That creates a new incentive for another kind of innovation, which is called product hopping, which is periodically, the frequency of once every 6 or 7 years, you reinvent the drug. And I'm going to use as my examples opioids, synthetic opioids, which is the FTC versus Impacts case. If you want to read it, it's on the website. In the Impacts case, the story was as follows. Impacts is a generic manufacturer, and the brand name opioid changed itself twice. First, it went from being a regular synthetic opioid to being a long-acting or opioid, which means you take one pill a day and it slowly releases opioids into your system over the course of the day, and you do this on a long-term basis. The second thing they did is add something called tamper resistance. Tamper resistance is you did something to change it, so it's more difficult to take the dosage in a long-acting pill and take it all at once, so you can get a better high. All right? So the brand name firm goes from the second part to the third part during the period when the generic is waiting, this waiting period. And then the generic signs on a settlement of the infringement case where it agrees it will come in at a date later than the second change in return for being paid $100 million. All right? Now, interestingly enough, the fact that this sequence of events occurred did not convince the hearing examiner that is, again, back to this pipeline theory. This was an innovation. We had a hardening of the drug to make it more difficult to use for nefarious purposes. Therefore, it couldn't have been anti-competitive. Now, the FTC as a body reversed it, and now there's an appeal. But notice it's the same fundamental argument that underpinned the Qualcomm, or the story in the Ninth Circuit about that affects the Qualcomm case, which is the notion that there's an innovation is sufficient to protect you. Now, subsequent history is the FDA forced the brand name company to withdraw its tamper-resistant version of the drug. So the generic ended up being the only drug on the market because it turns out that they didn't make it more difficult to use it in a nefarious way. They actually made it easier. But it was different, and that's all that counted. So here's an example of a technological regression delaying competition and harming consumers, but it wasn't enough. Okay, so the bottom line to all this is the institutional environment we have in regulation and antitrust rejiggers the incentives to innovate across a whole bunch of people in complex products. The rejiggering effect means if you, as a participant in this policy-making environment, want to have a true type, rule of reason type test, you have an almost impossible burden to prove that the rejiggering of the distribution of the rents undertaken by this anti-competitive conduct caused on net harm because it caused these guys to have more incentive to innovate and those guys to have less incentive to innovate, and who knows what the total effect is. Whoever bears the burden of proof in that kind of an environment loses. Thus far, we have a world in which plaintiffs bear that burden of proof, and for the most part, they lose. Thank you.
Well, thank you, Roger, and thank you for eloquently demonstrating something that's been said to me once, which is many relationships in life come and go, but your dissertation advisor is forever. There's a slightly less PC version, which I can share with you another time. Now it's my pleasure to introduce Herb, who is, I can imagine, no one better positioned to offer views on Roger's comments than Herb.
I was just thinking Roger should come to Penn Law and teach antitrust for a semester.
So I think someone else has that gig right now.
Well, thank you. I enjoyed those comments very much. I want to talk a minute about Frand and then a minute about Aspen skiing, about as much time as I have. Frand is a wonderful thing. It enables firms to innovate. Some of the innovators involved in a particular Frand agreement are competitors. Some are manufacturing complementary products. Some of them innovate less and manufacture more. Frand contemplates immediate and indemnified access to a shared pool of intellectual property rights. What that means is they're entitled to have it on the basis of the agreement, and I'm talking about in the ideal world where Frand actually works. And indemnified means they don't get caught up in a whirlpool of patent infringement cases. Okay, Roger mentioned 3 very backward, very damaging briefs that I think have the potential to undermine Frand if they are taken seriously, because currently Qualcomm is the bad boy in the Frand versus FTC story. But if the DOJ wins these arguments, there are going to be so many bad boys in Frand pools that Frand pools will not be able to hold together anymore. I think there's actually a more serious document that the Justice Department issued a little bit later than those 3 briefs, and that's their advice on remedies with respect to Frand encumbered patents. The principal remedy at issue is an injunction. I mean, Frand contemplates that there will be a royalty at either agreed upon or arbitrated terms, Frand royalty. The question is, when can one Frand member get an injunction against another Frand participant? Well, the answer is if they can get them too quickly, then Frand doesn't work. That is to say, an injunction should be a penalty for refusing to pay a Frand royalty once a Frand royalty has been determined by an independent third party. It's not supposed to be some sort of cowboy shoot-'em-up where you can go out there and keep other people from using your patents, because that's inconsistent with the obligation that you have made. And the Frand statement on injunctions is so strong, so out of character, indeed it does not even make the patentee's own misconduct a limitation on its right to seek an injunction. And that's a very, very old principle that comes not just from patent law, but from equity jurisprudence generally. He who seeks equity must do equity, or unclean hands. In this particular case, Qualcomm has violated numerous terms of its Frand obligation. It's engaged in tying arrangements, exclusive dealing, other forms of conditional licensing, refuses to license to competitors. All of those things are inconsistent with the Frand obligation to license to all people regardless of their status. You can't choose and pick, depending on whether they compete with you or not, on Frand terms. And like I say, the danger is going to be that if the DOJ gets its way in front of the Ninth Circuit, or perhaps eventually the Supreme Court, Qualcomm's not going to be the only bad guy in the Frand pool. There are going to be numerous of them, and then we will see an end to Frand and a very significant impediment on collaborative innovation. Now, the other thing I want to mention just a minute you got to be a little bit of an antitrust freak to know much about this, is the doctrine of aspen skiing. Okay, we have two big refusal to deal cases, unilateral refusal to deal cases in the last 40 years or so. Aspen Highlands, which condemned, 1985 case that condemned one firm's refusal to deal with another. And then a couple of decades later, Trinco, which refused to condemn. They're vastly different cases, although they are unfortunately too often glommed together into the same thing. Trinco deals with circumstances where it is very largely assumed that it's impossible for the plaintiff to do business without sufficient dealing to enable it to be hooked into the network. It's the telephone system, compatibility is essential, and so it's essential to be hooked into the network. However, the 1996 Telecommunications Act was already performing that function. It was already ordering Verizon to deal. And what Trinco really held was that we should put some limitations on the use of the antitrust laws to provide a remedy, including a treble damages remedy, on top of conduct where the regulatory agency was already doing its job, and in fact, a remedy had been given. That's an oversimplification, but it's good enough for our present purposes. Where Trinco applies, it applies on the premise that firms individually are unable to invest or operate in a market on their own, okay? In very sharp contrast, the Aspen Doctrine applies to firms who willingly undertook to do something collaboratively, and then later the rug was pulled out from under them because one of the parties reneged on the agreement. So the Aspen Doctrine, if it's properly interpreted, serves as an inducement to engage in joint investment, joint production, or joint innovation, because it protects those agreements once they have been developed. And one of the big problems here is that joint agreements produce a great deal of reliance, path dependence. History, we've got a vast history in the antitrust laws of joint agreements in which, even long before FRAND, firms would get together and they would decide on a kind of technology. Once they decided, that decision would guide the future course of product development and investment, and reversal, if possible at all, was extremely costly. And that's why I think Judge Koh was quite correct to rely on the Aspen skiing doctrine in her opinion, even though she's been roundly trashed for it. This was a case in which a very large group of people got together, made commitments to engage in joint development and joint production, and that the inducement to make that investment is worthwhile to the extent that it is protected by law. And if, as a result, if Qualcomm simply says, we're not going to honor this agreement anymore, we're going to license selectively, we're going to not license anymore to competitors, we're going to charge significantly higher royalties than the FRAND process would dictate, and we're going to engage in fairly traditional antitrust violations, including tying, exclusive dealing, most favored nation agreements, and loyalty agreements. If Qualcomm can just renege on those developments, it's going to very significantly reduce the incentive to engage in such joint investment in the future. So I'm quite distressed. I think Roger is too, by what the Justice Department, I didn't say it quite this way, but I think you are, by what the Justice Department is doing in this very sharp break. Why? Well, I'll give you my hunch, which is that the DOJ is listening more and more to old technology folks. You know, back in the old days when patents were mainly on heavy hardware or chemicals, there were many fewer of them. There was more truth to the lone inventor story. They were durable, and the products they were attached to was durable. That's the kind of patent system sometimes envisioned by more classical property rights theories that does admire the cowboy. On the other hand, innovation in information technologies is a totally different thing. It almost never happens in isolation. Sure, people get strong patents, but they're almost always patents that have to be used in conjunction with other people's technologies. Furthermore, there's a big range of technological choices to be made, the very important ones made very early in the history of joint ventures. One of my favorite joint ventures for study purposes is the one between Sony and Philips to develop digital disc technology. Originally the compact disc, culminating in the rewritable disc. And if you go along through that venture, you see all kinds of decisions that had to be made along the way. Do we use this approach or that approach? For example, the one that ended up in litigation in front of the Federal Circuit and the International Trade Commission involved a pretty technical decision that you've never thought about once, which is whether the stylus, the only reason they use that word is because phonograph records used to have stylus, but the stylus is a little piece of technology in a recordable DVD player that locates the spot where the previous recording stopped and the remainder of the disc is blank. Well, one of the two parties had a patent on digital technology for a stylus. The other party, one was Sony, the other Philips, had a patent on analog technology for the stylus. Although they were joining as a venture because they were producing complementary technologies. Sony was had a head start in the development of hardware, and Philips in recording technology. Although they joined because they were principally making complements, the fact is that their two alternative styluses were competing products. They ended up going with the analog technology because although it was older, it was more stable. And so they decided that, and then the subsequent litigation occurred because manufacturers, people who built DVD players, wanted to be able to promote a more high-tech product, and they wanted to use the digital. Version. But one of the important points is that once Sony and Philips together make that decision for whatever reason, that's going to have an enduring effect on products, future technology development, and so on. And that's where the Aspen rule becomes comes in very handy. When people jointly make decisions, they create path dependence, they create reliance, and then if someone, Qualcomm in this particular case, is able to renege on those arguments, commandeer a lot of the profits for itself, that can unravel the entire system. Thank you.
Well, Herb, I have to admit, when you said the phrase old technology folks, I was trying to figure out if the word old modified technology or folks and what that ultimately meant. And then I decided it probably didn't really make a difference.
Well, probably not.
Roger, any thoughts or response to Herb's comments?
Well, the areas of disagreement between Herb and I are so vast that I don't think I need to even address them. I have nothing to add. If I'd have thought of it, I'd have said what you said.
Michael.
So I agree with everything that you guys said. Just a couple points. One is that when we talk about DOJ, it's really just Del Rahim. As far as I can tell, this is just
Have you heard about major dissent within the Antitrust Division? I haven't heard about it. Are they just being really well behaved?
Yeah, so
That would be my first thought too. What about all the people that have been serving since the Clinton administration? They've got to be resisting this.
Sure, so I haven't heard that, but my sense is that, I mean, Del Rahim had this position a decade ago on the Antitrust Modernization Commission when you had a very conservative group, and he stood out for his patent position. And so I think the frustration here is that anyone who knows anything about innovation knows that it's nuanced, and it's cumulative, it's not just the initial invention, but the story, the myth of a patent is absolute property and I can do what I want with it, and that's what leads to innovation, is a powerful myth. And I think Del Rahim has ridden that for a long way. And then, Roger, just to get to the pharma point, I think pharma is interesting because you're always trying to trade off innovation against competition, but in the pharmaceutical industry, we have a regulatory regime that gives us guidance. So you have the Hatch-Waxman Act, you have state substitution laws, and one of the difficulties with product hopping is, as you say, as long as they can talk about one little innovation, it's game over. I don't think it has to be that way, however. So if you go back to the first product hopping case, the Tricor case, the court did apply the rule of reason and denied a motion to dismiss because there was a potential anti-competitive effect. And then my way of dealing with this is to adopt the no economic sense test, really conservative, but it applies and would find that all the litigated product hopping cases are actually antitrust violations because there's no reason for a brand company to pull a $1 billion drug off the market other than stifling the generic. So if we're worried about the rule of reason, maybe consider a no economic sense test.
So it's a weird thing. Am I remembering wrong? I thought Del Rahim was recused from Qualcomm Matters. And if that is, if I'm remembering correctly, then it's not coming from him unless it's people understanding the realities. But I have this vague notion that he's recused from
He should have been.
Should have
The
been,
question
yeah.
is why, whether he actually was.
Yeah. He was both an employee and a consultant
Yeah.
to Qualcomm at various points.
Well, to me, it's about institutional context then. What does the recusal mean if everyone understands what leaders, and this applies, up the chain to the White House? It's an interesting problem. Completely different matter. With the two agencies, one being nominally independent, the FTC does not have to clear its briefs with the Solicitor General's office and the Justice Department. And so this is one of the artifacts of our tradition of independent agencies. We get these spectacles, which would ordinarily have been worked out in a normal situation within the Justice Department of which position to take, is actually being fought out in front of the Ninth Circuit. And it's a really bizarre situation.
The DOJ statement on injunctions is legally illiterate. It really is. It's really pathetic how bad it is. And I know people who've been at the Justice Department for a long time. I just can't believe that they had anything to do with it. But I don't know what the explanation is.
So, the bottom line that I've never understood, and maybe Herb or Roger, you can explain to me. An injunction is a remedy at equity. This is why we actually teach it to students. And you're only supposed to do it when remedies at law are inadequate, where mere money damages isn't enough. If it's a Fran situation, you're only fighting over money. Exactly. So as a theoretical matter, we would apply the full typical balancing case factors, but as a practical matter, in Fran cases, shouldn't injunctions be per se denied?
Not quite. Not quite. There's one narrow possibility for an injunction, and that is if you carry your Fran disputes, so you own the Fran patent, I'm making something, we go all the way to the relevant tribunal. Fran royalties are set by either arbitrators or district courts. We got a pretty good history of both of them now. You get your royalty order from the relevant tribunal, and then you refuse to pay it.
I see.
And then you refuse to pay it. At that point, there's plenty of basis for saying you can get an injunction against somebody who refuses to pay a judgment issuing a certain royalty. But that's not what Qualcomm is doing. Qualcomm is suing willy-nilly, using threats of injunctions to ratchet up its royalties or to, it has a policy called no license, no chip, a blatant violation of Fran, which basically says if you want to license our Fran patent, you have to purchase our Fran modem chips. It's called a tying arrangement. And the Fran agreement expressly says unconditional licenses upon payment of a Fran issued royalty.
I would like to push another one of the buttons on Herb. What about the defense that it's just a contract dispute and there's no antitrust implication, Professor Hovenkamp?
Okay, there's two mistakes you want to avoid. One is saying that because it's a FRAND violation, it's also an antitrust violation. The other one is to say that because it is a breach of it is a breach of contract, that it cannot be an antitrust violation. Many antitrust violations started out as breach of contract violation. Sure, I mean, the great majority of franchise cases that involve tying arrangements and so on, they arise when the franchisee breaches an agreement, and then the question comes up whether the thing that agreement required amounts to an antitrust violation.
Shane.
I just have a question of fact. Both of you may know the answer. Qualcomm and Apple came to a very large agreement only some months ago, rather than go to judgment. Right? They got all the way to court, and then in their battle royale, and then they came to settlement. What role does that play in this?
I couldn't hear enough of what you said to know what you're talking about.
The Qualcomm and Apple.
Oh, yeah.
Right, had this. They were going to court. They had this big fight. They got all the way to court, and then they settled just before.
Yeah, and the terms of the settlement, as far as I know, are unknown.
Except that it's 6 years long.
And that the price and Apple stock dropped and Qualcomm stock rose. That's the best evidence we have of what's
I thought it was several $1 billion
I think the
transferred
thing that was
from
lurking
Apple
in the background,
to Qualcomm.
Shane, is that Intel has had hard luck with its modem chip production. And Apple was making an effort to switch away from Qualcomm and toward Intel. And when Intel had a couple of product failures, basically Apple realized that if it was going to go ahead with its iPhone programs, 5G iPhone programs, it was going to have to get a more reliable chip source, and so it caved and settled with Qualcomm. I think Apple's long-term goal is to avoid Qualcomm chips, but they can't do it right now.
And that's the generic attitude in the Valley, is everybody wants to avoid Qualcomm as soon as they can.
But the fact that they can't
But the fact that they can't, yeah.
Okay, but I see. So it's just one more example. Had Apple succeeded, would we have seen something different here? You're thinking perhaps
had Intel succeeded or Apple?
Intel, and then
Had Intel succeeded in displacing Qualcomm, I don't think it would have had any effect on the Department of Justice, no.
And I was at a conference where I was with an Apple antitrust attorney the day it came down. And they were...
Judge Koh's opinion?
Yeah, no, the settlement.
Oh, the settlement.
The settlement came down, and his reaction was basically, what a waste. You know, so if this is where we're going to end up, why did we go through all of this? You know, obviously they didn't know at the time they began that strategy how it was going to unravel, but it was a spectacular distraction for both companies. And
you have to understand Apple's position. It's got an enormous product flow in its future, and it can't. And 5G, is the next shiny object out there. They can't wait. They've got to have a reliable 5G chip, and they weren't getting it from Intel.
Camilla, you get the last question.
Well, I was wondering, I guess going back to the theme of sort of like effects on innovation policy, and Professor Noll, your argument that rejiggering of antitrust regulation has all kinds of effects on innovations. I was wondering if you could just say a little bit, and I guess this is sort of for all three of you, but mostly for Professor Noll, about how antitrust law defines innovation and what factors go into that definition. It's obviously not the same as some of the other definitions we've been talking about today.
It doesn't really define innovation per se. It just the case law and the way the cases actually proceed is that defendants make arguments that one of the benefits of what we did is it accelerated innovation. And it's sort of like an efficiency defense, except it's not the standard efficiency defense. So we will prove that by merging, we're going to cause the cost of the cell phone to go down by 4 cents. All right, then this is just a different kind of benefit, which is that in implementing this technological change that happened to have the effect it put half of the economy out of business, we got to improve our product by a significant amount. That's all that it means.
So any technical change is innovation.
Literally any change in the technology
I guess that definitely
is innovation.
doesn't comport with my conception.
No.
Not my person.
But this is about institutional, I want to say cowardice at this point, but in the United States, discomfort of courts to engage with technical decisions. And
Yeah,
so
I think
they
that's the key point. That's the key point, is that put yourself in the position. Steve Breyer has a book called Regulation and Its Reform. I forget, that's not the right title.
No,
He
it
wrote-
is.
Which he talks about his position as a judge in litigating a case about whether a particular chemical is carcinogenic, and how the whole thing is just over his head, right? And now put yourself in the position of a judge trying to make sense of a bunch of technical arguments by both sides where you don't understand the words. You don't even know the definition of the words. And then the question is, how are you going to react to that if you have to decide whether this firm had a great innovation or whether that's all just epiphenomenal and this was really an anti-competitive act?
But Roger, courts used to feel that way about economics, and they got over that.
Yes, that's right.
Well, we've reached the end of our time. Please join me thanking Roger and Herbert.